Welcome to Accommodate This, and welcome to the second video in a short series covering the history of disability benefits in the United States. In the previous video, we covered the history leading to the establishment of the NIH and Social Security. We continue our story in 1935, the year when Social Security was passed, along with FICA, the federal income tax used to finance the program. This is important because today's far right like to claim that Social Security is an entitlement that we can eliminate, and that the government can simply use those funds however they wish. However, that's not the case. Anyone who worked in this country has contributed to Social Security through federal income taxes. In fact, even workers who are not yet citizens, whether here legally and working through the citizenship process or illegally, their taxes go toward funding Social Security. Of course, if they are not legal citizens, they are unable to draw from those funds, but they still contribute to them. This is also a detail those on the right love to leave out when they try to convince the rest of us that immigrants are stealing our jobs and milking the system. But I digress. In 1935, discrimination against African American citizens continued without much enforcement of the laws previously passed. A wide-spreading grifting effort took hold in poll stations across the country, where they would charge African American voters before letting them cast their vote. This discrimination tactic became known as the poll tax, and had become so commonplace that many African Americans just decided not to vote. Considering everyone was counting their pennies during the Great Depression, who could blame them? And this is yet another example of marginalized citizens experiencing further marginalization. After passage of the Social Security Act, serious thought was given to whether that program should be expanded to provide wage-related benefits to workers who became permanently and totally disabled before age 65, and perhaps to their dependents. But this would be argued about for several more years, considering the Supreme Court at the time often clashed with FDR and his New Deal proposals. In 1937, the Supreme Court decided that poll taxes were constitutional, despite them being used to disenfranchise African American voters in the South. This decision would eventually lead to the passing of the 24th Amendment in years to come. In 1938, the debates about disability provisions continued. The Social Security Advisory Council feared that creating provisions for disabilities were not as subjective as race or national origin. And since they were so difficult to identify and verify, authorizing provisions for disabilities would lead to abuse, warning that it would position us for conditions experienced during the Great Depression, stating, "You will have workers like those in the Dust Bowl area, people who have migrated to California and elsewhere, who perhaps have not worked in a year or two, who will imagine they are disabled." To address the subjectivity of disability assessment, the actuary suggested a requirement for a formal medical examination. They warned that unless a highly qualified medical staff examined each applicant, the cost of the program would be higher than anything that can be forecast. However, most countries with old age insurance systems included protections for the permanently and totally disabled and did not find the administrative problems insurmountable. Yet the stigma and this line of thinking was enough to prevent any forward movement on the topic. This was yet another example of the slow movement of the government and how much this country resists change. But it's not like disabilities weren't having an impact on the economy. The following year, in 1939, World War II broke out. That same year, 57 life insurance companies in New York lost $29 million on permanent disability insurance. This amounts to almost $658 million in today's economy. Without the safety net of private insurance, many disabled citizens were suddenly left with no options for income. At the time, it was estimated that the entire insurance industry had lost over $500 million which is just over $11 billion today. In an effort to curtail losses, insurance companies tightened the definition of disability, making it even more difficult to become eligible for coverage. They also increased the waiting period before benefits were payable and placed restrictions on the types of persons to whom they would sell policies, even denying coverage to women. And most insurance companies eventually stopped selling disability insurance altogether. While the US was not officially part of the war yet, and we were just coming out of the Great Depression, the government took steps to strengthen the Social Security Act to protect benefits for the elderly and unemployed by enacting the Federal Insurance Contributions Act, or FICA. FICA essentially took the tax language from the Social Security Act and placed it in the same bucket as the Internal Revenue Code. FICA also expanded the old age insurance by adding payments for the spouses and children of retirees, called dependents or family benefits, as well as payments for families of workers who died prematurely, called survivor benefits. In 1941, the U.S. officially joined World War II after the attack on Pearl Harbor. And at that time, the Social Security Board was headed by a man named Arthur Altmeyer. Altmeyer stated the need for disability insurance might be even greater than the need for old age protection because the disabled often require medical and nursing care in addition to income maintenance. He proposed a program where insurance could be purchased by persons who had served in the U.S. military or naval forces during World War I, but the debate over disability assessment was still a major hurdle. Under the Altmeyer insurance program, disability was measured in terms of a reduction in earning capacity, to the extent that the worker could no longer engage in substantial gainful employment. However, due to the difficulty of assessing whether a disability was permanent, he proposed a 6-month waiting period to eliminate temporary impairments, and suggested a requirement for a medical examination to resolve any doubts about the disability. In cases where the worker was entitled to both disability insurance and workers' compensation, he suggested the Social Security benefit should be adjusted to ensure the total amount received did not exceed a specified limit. And that would avoid duplication of benefits and establish a clear division between the systems. He proposed the eligibility determination include input from a physician and labor market expert, and advocated for rehabilitation whenever there was a likelihood the worker could once again return to work. This was all based on Altmeyer's strongly held belief that disabilities should not be compensated unless they resulted in economic loss. That belief would influence disability laws for decades to come. In 1942, Roosevelt created the Civilian War Benefits Program to assist civil defense workers who became disabled during the Second World War. At that time, the Social Security Board was asked to administer the program because it already had expertise in benefit payments. This provided the Social Security Board with its first experience in adjudicating disability claims and provided it with an opportunity to test the program and to demonstrate competency in disability-related operations. In 1943, scientists discovered that DNA was the genetic material found in cells. After more than 1.5 centuries since the U.S. became a country, dozens more bureaus, committees, and institutions had been created as part of the Marine Hospital Service. And this discovery led to the establishment of even more. What started as a network of marine hospitals had evolved into several agencies with different standards and focus, and a lot of overlapping responsibilities. Tack onto that the fact that there was very little oversight for these agencies, and because of immense ambiguity and a lack of standards, these issues accumulated in a ton of dysregulation across the country. So President Franklin D. Roosevelt requested that these agencies be organized and consolidated through passes of the Public Health Services Act of 1944. This act not only addressed a lot of those issues, but it was also used to officially change the name of the National Institute of Health to the National Institutes of Health, plural. The National Cancer Institute, or NCI, one of the most prominent agencies, became a division of the NIH, which was consolidated with the Bureau of State Services and Bureau of Medical Services. This act provided a legal basis and standard for providing public health services in the United States. The next few years were a period of experimentation, where those running Social Security would be put to the test. World War II ended in 1945. Then the Social Security Board was renamed to the Social Security Administration in 1946. In 1947, the Cold War began, and in 1948, the Social Security Administration began to look at other civil rights, including disability rights. At that time, private insurance companies no longer offered disability insurance to women, except under very restrictive conditions. The Social Security Advisory Council made a strong case to cover total and permanent disability, reporting an estimated 2 million individuals on any given day were unable to work because of impairments that lasted for at least 6 months, and argued the economic hardship imposed by disability was often greater than that created by old age or death. They also concluded that a Social Security disability program would not constitute a wholly new expense, since many disabled workers were already receiving welfare payments of some type. They did not see the experiences and concerns expressed by private insurance companies as conclusive, and they were confident in the ability of the Social Security Administration to administer a disability program based on their performance during World War II. So the Social Security Advisory Council recommended a program with several additional restrictions to make it possible. Dissenters argued a cash benefit was a deterrent to rehabilitation efforts, predicting the system would break down during a period of high unemployment, just as private insurance companies experienced in the 1930s. They even expressed concerns about including female workers in the program, claiming women were more inclined to claim ailments that are difficult to disprove. Misogyny. So ridiculous. They also proposed establishing federal grants at the state level. So there's many parallels with today. In 1949, the House of Representatives passed a bill containing provisions for benefits under Title II of the Social Security Act to permanently and totally disabled insured workers. However, the Senate passed version sided with the dissenters, making no provision for disability insurance benefits. Instead, provision was made for grants to the states for public assistance to permanently and totally disabled individuals. That was the version that was adopted in the Social Security Act Amendment of 1950, the same year the Korean War began. While the amendment didn't include everything proposed by the House, it placed the Social Security program on the road to virtually universal coverage and introduced a cost of living adjustment, or COLA. In 1952, Altmaier continued to influence discussions related to disability benefits, and he pointed out a potential loophole that would hurt disabled citizens because they could potentially lose old age and survivor benefits if they became disabled before reaching the eligible age. Since entitlement to retirement benefits was dependent on covered employment for a specified length of time, a worker who was forced to leave the workforce due to disability could lose entitlement to retirement benefits. Altmaier suggested a disability freeze that would exclude any period of disability, so it would no longer count against them when it came time to collect the retirement insurance and from the average monthly wage in claims for old age or survivor's benefits. Social Security amendments of 1952 included a measure providing for the establishment of a disability freeze, designed to protect the benefit rights of workers and their dependents, However, this never took effect because Congress never took any action on the measure before it expired. So the freeze ended in 1953, as did the Korean War. But the drafted amendment did not go to waste. The year 1954 was a defining time for a few reasons. One, the Supreme Court ruled that segregation was unconstitutional, which spurned the move against desegregation. That decision would eventually prove to benefit the disabled community in years to come as well. Two, the French had withdrawn from Vietnam, marking the beginning of the Vietnam War. And although the US didn't join the war effort for a few more years, we contributed small-scale troops to assist in the early 1950s. And three, the Social Security amendments of 1954 created the first actual Social Security disability program, based on the draft of the disability freeze from a couple years earlier. The amendment included referring disabled persons to state rehabilitation agencies who would make the final disability determination. At that time, the definition of disability meant inability to engage in any substantial, gainful activity by reason of any medically determinable physical or mental impairment which can be expected to result in death or to be of long continued and indefinite duration. This definition was considered conservative, even for its time, but nobody really had a better one. So they continued in the assumption that state agencies would eventually work out a better definition as time went on. This left it up to the states to define disabilities based on severity, which you can imagine was not the best approach. Many opponents of the law pushed for rehabilitation services instead of cash benefits, claiming rehabilitation would provide the disabled person with a sense of independence, pride, and usefulness by returning to work or learning a new job suited to their limitations. So, eligibility for a cash benefit was limited to persons whose disability had lasted for at least 6 months and whose earnings record demonstrated a strong and recent connection to the workforce. And to address issues with dysregulation, it was decided that disability determinations would be made by the state under agreements with the Secretary of the Department of Health, Education, and Welfare, or DHEW. This provided the necessary unity for keeping things fair and consistent. Of course, this unity is under attack by Trump's administration today. In 1955, the House Committee on Ways and Means passed H.R. 7225 to close the gap that the freeze was aimed to address. They stated, "Your committee believes that retirement protections for 70 million workers under old age and survivor insurance is incomplete because it does not now provide a lower retirement age for those who are demonstrably retired by reason of a permanent and total disability. We recommend the closing of this serious gap in the old age and survivors insurance system by providing for the payment of retirement benefits at age 50 to those regular workers who are forced into premature retirement because of disability." While this was a significant step forward, it did not include a provision for the dependents of disabled workers. Realizing that leaving the definition up to the states put them back into the same situation they had before Roosevelt suggested consolidation of the NIH, a medical advisory committee was formed in 1955 to define uniform standards for evaluating disability. At that time, many people believed mental disabilities should not be paid, arguing most people with mental disabilities were already taken care of in state hospitals. They were difficult to diagnose, and they created problems in foreign disability insurance programs. There was also a fear that people may suspiciously fake a mental disability to gain benefits, a practice known as malingering. The Social Security Amendments of 1956 established monthly disability insurance benefits between ages 50 and 65, and for disabled children of retired or deceased insurance workers if the child was disabled before 18. This amendment established a separate trust fund for paying disability insurance benefits, which would be financed by additional payroll and self-employment taxes. It also included a 6-month waiting period for receipt of benefits and other restrictions, making it difficult for the insured to obtain funds through deception, preventing double dipping, and created loopholes for suspending benefits without good cause. In 1957, the Social Security Administration published regulations outlining factors to be considered in determining disability impairment, including the individual's education, training, and work experience. The Civil Rights Act of 1957 also passed, which created the U.S. Commission on Civil Rights and U.S. Department of Justice Civil Rights Division to enforce previously passed civil rights laws, reinforcing voting rights for African Americans. Later that year, and again in 1958, the Social Security amendments expanded the program by including benefits for dependents of disabled workers. Specifically, the 1958 amendments, which repealed the offset for beneficiaries of workers' compensation or other federal disability benefits, loosened the insured status requirements, and provided for 12 months of retroactivity. Although it seemed civil rights laws were rapidly expanding, they were still being resisted. So the Civil Rights Act of 1960 established penalties for anyone who obstructed someone's right to vote. This act closed loopholes from the 1957 Act and extended the Civil Rights Commission so it could oversee voting registration and practices. Also in 1960, the Social Security Administration was beginning to feel the strain of their responsibilities and were regretting the push toward rehabilitation for older beneficiaries. The adage, "you can't teach an old dog new tricks," comes to mind, as the biggest driver for the 1960 Social Security amendments was the belief that older workers made the worst candidates for rehabilitation. Agencies were finding they could not cope with the large numbers of people applying for benefits, and cited the fact that older beneficiaries tended to have different reasons for applying for disability coverage. For example, older applicants were affected by heart disease and arthritis, whereas younger applicants were affected by mental impairments. This essentially made disability insurance a retirement program of its own, which was counter to the original intent and fractured the administration of a single program. So the Social Security amendments of 1960 removed the minimum age requirement of 50 years for disability insurance benefits, eliminated the 6-month waiting period for disability that recurred after an apparent recovery, and established a 9-month trial work period during which the disabled beneficiary could test their ability to work without suffering a loss of benefits. In 1961, the U.S. began scaling up the number of troops sent off to the Vietnam War, but we were still 4 years away from officially joining. In 1963, Martin Luther King Jr. gave his iconic "I Have a Dream" speech, and the Equal Pay Act was passed, which aimed to abolish pay disparities based on sex. The following year, in 1964, the 24th Amendment of the Constitution was passed, which finally eliminated poll taxes. It took almost 30 years, people, and a Civil Rights Act was also passed to require equal opportunities and rights without regard to race, color, religion, sex, and national origin. These affirmative actions applied to education, employment, public accommodations, and voting rights. The act also expanded the Civil Rights Commission established by the 1957 Civil Rights Act and created the Equal Employment Opportunity Commission, or EEOC. Fast forward to today, Trump and Musk have claimed to shut down the EEOC after 68 years. In 1965, the U.S. officially joined the Vietnam War, again placing significant strain on disability and unemployment. That same year, Martin Luther King Jr. marched in Selma, urging the government to reinforce previous laws. Ultimately, the Voting Rights Act of 1965 was passed, which prohibits racial discrimination in voting. They also passed Social Security amendments establishing Medicaid for the poor and Medicare for the elderly and disabled, and eliminated the requirement that impairment must be of long continued and indefinite duration. Instead, they replaced it with expected to last for a continuous period of not less than 12 months. This, combined with war injuries and increased public awareness, caused the Social Security disability program to grow significantly. To counter the rise in costs, the amendment restored the offset at around 80% and placed a limit on attorneys' fees to protect claimants from contingency agreements that enabled attorneys to collect an unreasonable percentage of past due benefits. There's a story behind that one, but I won't get into that today. Next time, join me as I discuss the history leading to passage of the most significant law benefiting America's disabled population. You won't want to miss it. Until then, thank you for watching. If you enjoyed this video, please comment, like, and subscribe to see more content like this, or click on the video here to continue watching.